Steffi for the nice technical introduction and the nice picture. And I want first to say, everybody, thank you to be here today for this important topic regarding invention, secret or seeking patent protections. How are European SMEs better off? And first, I want to say thank you to our host today, Ivan Stefanec, member of the European Parliament and also our president of SME Europe. So thank you very much. And I will pass over directly to him for the welcome, because we have 60 minutes of power for a very interesting topic, and we want to use any time we have. And of course, the audience can have also questions to our speakers and experts at the end of the presentation. Please, Ivan, take over the floor.
Thank you very much, Horst. Good morning, everybody, dear friends. In this webinar today, we want to discuss on the best strategies for European SMEs to protect their intangible assets. And theft of intellectual property rights is increasingly done through unlawful access to computer networks, as we know. Cyber theft of trade secrets accounts for an estimated 60 billion euro of losses in the European Union. And today, in time of growing importance of digitization, we clearly see we need to deal much more with the protection of intellectual ownership. Just for our information, currently China approves almost 4 times more patents than the European Union, and United States almost 3 times more than the European Union. That's the situation where we are. Patents and trade secrets, exactly as the others of the bunch of intellectual property rights, trademarks, designs, copyright, geographical indications, plant variety rights, help companies to protect and commercialize their intangible assets, fight unauthorized copying by competitors, and provide them with a source of competitive advantage. Today, we want to discuss advantages and also disadvantages for businesses of choosing one of each protection mechanism. Sometimes it might be smarter not to seek formal patent protection, especially for small businesses, in order to save costs. Dr. Eva Wilneger, a Belgian and European patent attorney, might have some advice as a practitioner. While large companies have the resources to manage a large portfolio of intellectual property rights, such as patents, smaller companies often cannot afford to do this. Therefore, their reliance on trade secrets is greater, as we know. I'm sure that my great colleague and great friend Paul Rubik, member of the European Economic and Social Committee, who is also a businessman, he can give us some insights. This discussion is timely, as unfortunately we are still waiting for the European unitary patent system to come finally into force. As you know, Brexit has further delayed the establishment of the unified patent court, which should have had one of its 3 branches in London. Maybe Mr. Jan Menier from the European Patent Office in Munich will also touch upon this burning issue. And last but not least, I'd like to thank our friend Mr. Udo Pux from the European Parliament think tank for having had the idea for this conference and this initiative. Thank you very much, dear friends. Horst, back to you.
Thank you very much, Ivan Stefanec, for this nice introduction. Welcome. I think we're coming now directly to the opening, and I want to say we have 90 minutes to discuss it, not only 60 minutes. And I think it's a very interesting topic. And the opening will be by Dr. Udo Pux, IP specialist, European Parliament research, speaking on patents and trade secrets, registration versus secrecy. Please, the floor is yours.
Hello, good morning, Horst Heitz. Good morning, Dr. Stefanec. Greetings from Brussels. So, press release, US Department of Justice, 22nd April 2021, Greenville, Tennessee. Following a 12-day trial, Dr. Xiaorong Yu, age 59, of Lansing, Michigan, was convicted of conspiracy to commit economic espionage, conspiracy to steal trade secrets, possession of stolen trade secrets, and wire fraud. According to evidence presented at trial, Dr. Xiaorong Yu Her research was related to formulation for bisphenol A-free coatings for the inside of beverage cans. From 2012 to 2017, Dr. Yu was employed as principal engineer for global research at Coca-Cola Company, Atlanta, Georgia. Bisphenol A was always used to coat the inside of cans and other beverage containers to help minimize flavor loss and prevent the container from reacting with the beverage contained in the can. However, due to potential health risks, companies began searching for bisphenol A-free alternatives. Developing these is a very expensive and time-consuming process. Because of Dr. Yu's extensive education and experience with coating technologies, she was one of a limited number of Coca-Cola employees with access to trade secrets belonging to companies like AkzoNobel, BASF, Dow Chemical, and others. Dr. Yu stole these trade secrets, which cost nearly $120 million, for the purpose of competing in a Chinese government-sponsored program called the 1,000 Talents, which encourages individuals with advanced education and experience living in the Western countries to return to China. While in this case, Coca-Cola's famous secret formula remained intact, Dr. Yu is accused to have taken pictures of files on her computer to bypass Coca-Cola's security measures and to have transferred trade secrets information to an external hard drive. So this was a very recent press release. Now I want to give you an insight into two specific intellectual property rights, as we already heard in the introduction: patents and trade secrets, and the advantages and disadvantages for businesses when they have to protect their creative portfolio against competitors. So that is what is at stake. Dr. Stefanetz already mentioned different IP instruments. It's all together. It can be even in one product that we have different. Yes, the one with the sneakers. Thank you. And it is now, I start with the patent. As you know, patent, next slide, please. Patent is a legal title that can be granted for any invention, granting process, invention that has a technical character, provided that it's new and it involves an inventive step and is fit for industrial application. Next slide, please. In return for the exclusive right granted by a patent, inventors have to disclose the secrets behind their inventions and pay application and renewal fees for the granting authority. Patents offer exclusive rights up to 20 years over inventions that are not part of a list of subject matters that are by definition not patentable. In the international level, we have Article 27, paragraph 2 of the TRIPS agreement, which provides that member states can exclude patentability inventions when they contradict ordre public or morality. Next slide, please. The idea behind the patent is therefore some form of social contract between society and the inventor. The patent acts as an incentive to disclose otherwise secret information, to disclose it, thus making it completely available for the general public and third parties, and to allow to generate follow-up inventions. But after 20 years of term, the formerly secret information made public becomes now part of the public domain, and from now on can be used freely. Within the 20 years where the patent protection is granted, the original inventor has, through the monopoly rights, provided a means to recuperate his investment made formerly to research and development, and the assumption is that such R&D investments would have otherwise possibly not been made. So this checklist you have here for the patents is nearly the opposite checklist which you have to tick when you talk about trade secrets. All these points we have in patents, they are not valuable for trade secrets. And so you have a real choice, and sometimes the choice may be smarter not to seek patent protection. Now, trade secrets. You choose to keep your invention secret. I don't like the term trade secret so much. In German, Geschäftsgeheimnis is a better term, or even in French, secret d'affaires. I don't know what trade in this is not very handsome, but okay, it's called trade secret since 100 years. I like better the term know-how, knowledge. So in any case, you have here the famous Coca-Cola. The trade secret is a valuable piece of information for an enterprise that is treated as confidential, and that gives that enterprise a competitive advantage. Probably the most famous example we have here is the famous Coca-Cola formula, which is a trade secret, not a patent. If it had been a patent, long time ago, it would have already been expired and the Coca-Cola formula would have been freely on the market, but it is not. Next slide, please. As we have seen in the case of the beverage can coatings earlier, such knowledge or know-how can include new manufacturing process, as example, improved recipes, information on whom to buy from, information on whom to sell to. Different types of confidential commercial information may be protected. It can be the design of a prototype of a new rally car or a tire, car tire, engine parts, the design of a new carpet grip, or the information on the next country where a company intends to do its business. A trade secret may equally extend to the service sector, like, for example, covering management techniques of international hotel services. Information protected can be strategic for decades. For example, this recipe or a chemical compound, or it can be very short-term, ephemeral. For example, the results of a marketing study, or the name or the price or the launch date of a new product, or the price which we want to offer in a bidding procedure. Next slide, please. We have trade secrets, of course. The challenge is the reverse engineering, which is not allowed in case of patent, but of course it is allowed in the case of trade secrets, because no protection is offered once the information is uncovered. Reverse engineering is completely lawful. And also trade secrets can potentially last forever, as we have seen, provided the information in fact remains secret. Once the secret is out, the business value is lost and the trade secret protection ends. Next slide, please. As I said, the trade secrets are part of IP rights, not so old like patents. It's a relatively modern IP right and not so formalized, and it's protected in the property guarantee of the Charter of the Fundamental Rights of the EU, and then more specifically in Article 118 TFU. Next slide, please, because there you have the text of the legal base, which is the one for the patent, the unitary European patent, and all the patent legislation, plant varieties, and also the trade secret directive. I will not touch about on the European patent. We have experts here which can tell more about this. I'm sure Mr. Menier can tell us the state of play of the European unitary patent. But the trade secrets directive is already in force. Next slide, please. It is the Directive 2016/943, and it harmonizes the definition of trade secrets, of course, in the first place. Trade secrets a la European Union, because there is also, as we have seen, TRIPS, WHO, and international treaties on definition of trade secrets. But of course, European Trade Secrets Directive is only EU. For example, it says that it has to be seen in the context of the freedom of expression. It defines what is unlawful conduct when revealing trade secrets. And this is the scope of the directive. And we see clearly that also the Trade Secrets Directive of the EU has not touched upon criminal law. It's only the civil means through which a victim of trade secrets misappropriation can seek protection. For example, in the first place, stopping the unlawful use and further disclose of misappropriate trade secrets, immediate removal from the market of the goods that have been manufactured on the basis of a trade secret, and the right of compensation for damages caused by unlawful use. Before, of course, this has also to be seen in the digital context. Before, the trade secrets were stolen by copying or physical document or an object in the firm. Today, the industrial espionage is, of course, done more and more by access to computer networks, and the European Commission has already offered a working program to protect small and medium enterprises and to better secure their networks and IT. Next slide, please. So this is in the international context. You have the definition of patents in Article 27, paragraph 1 of the TRIPS agreement from 1990. And you have the Article 39, paragraph 2, which is talking about trade secrets. And as you see, the word trade secrets in the TRIPS, in the international context, is not used. It's just said information that is secret. Next slide, please. To sum up now, the two opposing choices we will hear now today, we can look at them on different angles on trade secrets. Trade secrets has an aspect of unfair competition, so competition law between business to business, between companies. It has, of course, the contractual side between the company and an employee. It can be the commercial contact with another company, small company, or individual person, or it can be touching about the labor contract between the employee and the firm. And of course, we have the third angle, which is the perspective of legitimate transparency. We have freedom of speech, whistleblowing, is not to disclosing some information can be absolutely fine, and disclosing it can be within the limit of freedom of speech. And the sanctions which the company has against the unlawful appropriation can be, of course, then contractual, based on the breach of contract, labor contract, or civil contract, or they can be even based criminal, but this is not defined in the Trade Secrets Directive. It's in national criminal law. Next slide, please. And the last one, we have now to, no, sorry, back. This is not, that was already the last. If you choose not to go into the public domain, you might be better off. That's the conclusion. Opposing choices. It is clear that a patent is very formalized. It can be invalidated immediately if the inventor refrains from describing all and important details. This is called the enablement. It requires that the patentee has to disclose enough information for others to use the invention later on after the patent period has expired. And you, of course, you have the cost aspect. That was a very important point when we discussed 20, 30 years ago, the European unitary patent. The cost for filing can be enormous. Translation costs, Eva Wilniger is expert about translation, I think she will tell us. And renewing patents becomes increasingly more expensive the longer a patent lasts. So it's a smart evaluation businesses have to do any time when choosing the patenting or not, or hiding the information, because even if your product is patentable, companies always have to ask themselves, will my invention be useful beyond 20 years? Then I will maybe choose the trade secret. Is it possible for other companies to reverse engineer it anyway? Or is the invention easily detectable and embedded in the product already itself, or is it part of an internal manufacturing process? Is the invention likely to be independently discovered in the near future anyway? So that is the overview. Thank you very much for your attention, and I'm happy to discuss.
Thank you very much, Dr. Books, for this presentation, this overview to give us a clear picture what is the difference between a patent and a trade secret and what are the advantages and disadvantages. And now we're coming to the keynotes. I think there we will go deeper to the topic. We start with Jan Minier, European Patent Office, Brussels, speaking on patents and trade secrets, opposing choices or complementary IP rights. Please, the floor is yours.
Thank you. And Mr. Stefanek, Mr. Rubik, dear panelists, ladies and gentlemen, good morning. It's a great pleasure to be here, and I'm grateful for the invitation, especially for this topic. It's a very important topic to us at the EPO. It's key to understand the value created by patents and the way in which our applicants use patents to create value and to bring technology to the market. And this is why we have been studying it a lot at the EPO and also with our colleagues of the EU IPO. And with this presentation, I will share some insights from this research carried out in the past years. And let me start by discussing what is at stake, actually. So, as I see it, a very large part of the EU economy is concerned by this question of patent versus trade secret, and this concerns actually all IPR-intensive industries. We measure regularly with the EU IPO the contribution of these industries to the EU economy, and in our latest study we found that they represent about 45% of GDP, 39% of employment, and the bulk of the EU trade, with a trade surplus generated for Europe. And why are they concerned by trade secrets? In fact, the way to see that is to look more closely at these figures that are on the slides. And if you compare actually the contribution to GDP and to employment, you see that there's a higher contribution to GDP than to employment. That means that these industries create more value added per employee than other industries. And the reason for that is that they are knowledge intensive. They invest in the creation of knowledge, and this is the means to create more value added. This is the means to be more competitive on the global scale. And the reflection of that is that the employees in these knowledge intensive industries are generally more qualified, they are more productive because the value added per employee is higher, which results in higher wages, as you can see also here. So this question of trade secret versus patents for the protection of knowledge assets concerns all knowledge intensive industries, which are equivalent to IPR intensive industries. And actually, from that perspective, trade secret should be considered, as rightly said by Mr. Books, as one more option in the set of IP rights that are available to companies to protect their intellectual assets. And looking at trade secret that way, we see indeed that there is a strong complementarity or a strong correlation between the use of trade secret and the use of patents at the industry level. So this chart comes from a study published by EU IPO, and each dot represents an industry on the chart. And on the x-axis, you have the intensity, the frequency of the use of trade secret, and on the y-axis, you have the intensity of the use of patents. And you clearly see that those industries that intensively use patents also strongly rely on trade secret. So again, this should not be a surprise. It simply means that these industries are knowledge intensive. They have intellectual assets and they need to protect them. And they use a bundle of IP rights, including patents and trade secrets to protect them. The way I would see it is like an iceberg. Knowledge assets, intangible assets are like an iceberg. And the patented part is the part that is visible, but beneath, under the sea, you have also a lot of knowledge that is not patented. And that consists, for instance, of know-how that is not even codified, or sometimes of codified knowledge that is kept secret because it's more difficult to reverse engineer or to copy, to access. Typically, for instance, for process inventions, it's more difficult for a competitor to have to access to a process inventions because it's hidden behind the walls, under the roof. And then it's probably safer to bet on secrecy than for a product invention. For instance, typically a drug, it takes a lot of money to develop a drug, but once it's commercialized, it's a product on the market, it can be easily accessed, reverse engineered and copied. There you need a patent. So at the end of the day, it's a question of how do I protect my knowledge, my intangible assets, and what is the trade-off between the use of a patent versus a trade secret. And this trade-off has been very well discussed by Mr. Books. So I will repeat part of it quickly, but I would like to add a few comments. So what drives the decision to file a patent? What are the benefits and the costs for the inventor? Actually, as said by Mr. Books, it's a matter of having a contract with society. By filing a patent as an applicant, I can get the benefit of strong legal protection for a limited period of time. And with that protection, I can better secure my market. I can probably enhance my margins and better secure return on the R&D investment. And looking forward, the availability of patent protection is a strong incentive to invest in research, in R&D, because there is this prospect of having a secure legal protection. So that's the first part, a policy tool to incentivize investment in R&D. But there is a counterpart to that, which is the publication of the patent application with a lot of details on the invention. Actually, the publication should be such that it enables third party to reproduce the invention. And this is primarily meant to benefit the public. This information becomes codified. It's not anymore pure know-how or hidden coded knowledge. It becomes public, available to all, searchable to all. And as a matter of fact, we know that patent information is the main source, for instance, of intelligence on competitors' R&D, often for companies. That has a strong benefit to society, and available studies show that the private return on research is twice higher than the public return on research on R&D is twice higher than the private return on R&D, because the knowledge diffuses, can be used for a long time, sometimes for centuries. Think about the wheel, for instance. Well, this is still useful and still creating value, although it was invented centuries ago. So important inventions last well beyond their inventors, and it would be a pity not to publish them because they may be lost. Actually. And that's a strong benefit of the patent system as compared with the secrecy for society. But there is another aspect that is increasingly important for companies. It's that the publication of the invention makes it possible, combined with the legal protection, makes it possible to organize transactions focused on knowledge. And in today's knowledge economy, where collaboration is increasingly important, this is key. Actually, this is something that is very difficult to do with secret, because well, there's this well-known knowledge paradox. If you want to sell or to convince a third party of the value of your technology, you have to show it. But once you have shown it, if it's not protected, well, you cannot have a contract anymore because the technology is gone. You have given the knowledge. It's already shared. And so that's very difficult to overcome. All licensing managers know well that even with a patent, it takes a lot of time to carefully advance to disclose the secret part. And the patent is not only useful, but critical actually to organize such transactions, such discussions, to build contracts on the basis of knowledge. And this is especially important for SMEs. And this is what I would like to develop in the rest of my presentation. So what is the benefit of adding a patent on top of adding a patent layer on the knowledge, on the intellectual assets? So we have some studies measuring that benefits, and both of them are focused on are rigorous in the sense that they really compare apples with apples and pears with pears. We compare SMEs or large firms within the same sector, same age, same size. And on this basis, we find that SMEs that own a patent enjoy a 50% premium in terms of revenue per employee, as compared with those that do not use a patent. We also have such a premium for large firms, but interestingly, the premium is especially high for small businesses. So having this secure legal protection makes a big difference for these small applicants. So we could also argue that it was said that there's a cost of using a patent. So maybe these SMEs use patents because they are more successful, they are richer. So one way to check that is to look at their growth, actually. So in another study with our colleagues of EYPO, we checked whether SMEs have filed patents in a given time period, and then we checked their growth in the subsequent period, so after in the next period. And again, we find a strong correlation between the use of patents and subsequent growth, and even the likelihood of high growth, meaning plus 20%, at least 20% of turnover growth during 3 consecutive years. And all of that is correlated with the use of IP, even more with the use of patents, and even more with the use of European patents. And this should not come as a surprise. It means that these companies are using patents to protect intellectual assets. They are innovative, so more likely to grow. And in the case of European patents, they file European patents because they want European-wide protection, meaning that they are planning to grow internationally, which is the right way for SMEs and startups to scale up today in Europe. And importantly, those SMEs that use patents and seem to generally succeed with patents do not only use patents to prevent imitation. So it's very certainly this function of preventing imitation, where the trade secret is an option as well. But they also use a lot patents for what I would call transactional purposes. Patents are a way for them to enhance their reputation vis-à-vis investors, vis-à-vis customers. It's a way for them to secure freedom to operate in case the invention is, for instance, patented by a third party. It's a way for them to build contracts, to organize licensing, and to raise funding increasingly, especially for startups. VC funds are increasingly sensitive for deep tech investment to the not only the fact of using patents, but the quality of the patent protection, which is a very good development in Europe. As a last word, I would like to emphasize why this transactional function is important. And for that, let me quote results from a survey of our of SMEs that file with the EPO. And we asked them whether they succeed in commercializing their inventions. And we find that about 2/3 of them do commercialize their patented inventions, which is quite high. Most of the remaining third, it's because the invention is still in development, for instance, or it turns out the market is not as big as expected, but 2/3 succeed. And for those that succeed, half of them do that through external partnerships. And that should not be a surprise. SMEs are small by definition. They do not have many assets, and they have to rely on third party to enter new markets, to organize manufacturing, to carry out R&D and use technology that they do not master. Therefore, partnerships are especially important for small businesses to commercialize their technology. And these partnerships are focused on technology. And so, again, patents are absolutely instrumental for that. And as a last remark, in response to Mr. Stefanek and Mr. Books, I would like also to mention that we find in this survey that most of their external partners are European. And actually, when we ask them, what kind of partner are you looking for? An even larger proportion of them say they are searching for partners in the rest of Europe. And we see indeed that European markets, so beyond their national market, is the natural way for them to grow and to scale up. So this is where they have to find partners. And this is why they need pan-European protection. And this is why you are impatient, and we are as well, to see the entry into force of the unitary patent, which will very much facilitate access to this pan-European protection. And the prospect is good in that respect, because as you probably know, the German Constitutional Court rejected the complaint that was filed against the unitary patent in summer, and the instruments were just deposited by Germany yesterday, actually. So now we are waiting for one more country, could be Austria, Slovenia, or Malta, in the coming weeks or a few months. And we expect the unitary patent to enter into force in the second half of 2022. This, I thank you for your attention, and I would be very happy, of course, to discuss and take questions. Thank you.
Thank you very much for this presentation with a lot of data. I think this is always important that we know what we are talking about, what this means in reality. But we're coming now also to the practical side, to Dr. Eva Wilnegger, European and Belgian Patent Attorney, speaking on avoiding the cost trap by using the correct protection mechanism for SMEs. I have to say, I like your signature with this little tank and patents are weapons. Please, we want to hear more about this. The floor is yours.
Thank you. I'm trying to share screen if that is possible. Share and to the presentation. Thanks for the invitation also from my side. It really is a pleasure to talk with such a high-ranking panel. I will address the practical points because I've spent my entire life in industry as a patent attorney and a lawyer. I was with BASF, then Owens Corning, and then Philip Morris before actually founding my own IP advisory here in Brussels. So the first question, of course, when we talk about costs, we have the patent office costs, but then we have the legal fees that have to be paid. So what is a patent attorney? The patent attorney actually has a technical qualification. Very often he's got a PhD or a master degree or in science or in engineering. That's the two main focus area. Mathematics now with computing is also on the rise. And then we have a 3 years training where we actually have to serve at a, with an experienced, work with an experienced patent practitioner to get up to speed. And then the patent office exam. And it's important to state, and I can only stress that a patent attorney only adds real value when he's seen a lot, basically when he's in the beginning of his earliest 40s, right? That's just, he has to have seen a lot. And this is why, we charge so much on an hourly basis. Currently, we have exactly today 12,638 European patent attorneys entered or registered at the European Patent Office. So this is the big pool of professionals that is at the disposal of SMEs in Europe. What costs a patent? And that varies widely. It can be done completely inexpensively by keeping, sticking to the key points and keeping the description short, avoiding, as Dr. Book said, the enormous translation costs by, using machine translations, keeping the description sticking to the key points. But nevertheless, the typical costs of a patent family in the top five meaning Europe, US, Japan, Korea, and China, over the lifetime of a patent would be in the 200,000s. Yeah, could be less, but that would be a cost indicator. So it's a substantial amount of money for one invention, and we all know that nowadays we need to work with portfolios to protect the technology. Then we have the costs of enforcing a patent, and here we look at Also in the at least 100,000 if it's here. If it's in the US, we start with 1 million basically to enforce a patent. It's a very, very expensive hobby, and that makes it very difficult for SMEs obviously to faire respecter, also to enforce their patents. However, we've already heard from the European Patent Office that patents are used to create value in different senses, but there are also very interesting tax deductions through patents. And we had also a comment in the comment section, the digital exchange of intellectual property, which I'd like to learn more about what tax impacts that has from the, it was Peter Regent that made this comment. So the tax deductions are actually quite interesting. It depends a bit on the country, the market. They are OECD standardized, but here in Belgium, for example, we end up with a tax rate for innovation income of 3.75%, so below 4%, which is of course very interesting for any SME. As compared to that, a trade secret is of course much cheaper to register a trade secret, for example, as an IDPO at the Benelux Patent Office for 5 years. Renewable would only be 37 euros, so it's very inexpensive, can be renewed. But as we have heard, there's a lot of misappropriation of trade secrets. We have heard the Coca-Cola case by Dr. Books. It's very expensive to track and trace all the requirements and to put up all the requirements to limit the access to trade secrets and to effectively protect that. We have for SMEs here in Wallonia, for example, in Belgium, very attractive subsidies. So SMEs can get up to 50% of their patent costs up to the grant of the patent reimbursed. It's a bit of administrative burden, but still nevertheless very attractive offer for the SMEs here. In other countries have similar programs. However, what we've seen here in Wallonia is that the patent law firms have actually a very increased level of pricing, which is probably driven by those subsidies, and the outcome that shows that the outcome is always a bit different than the lawmaker's intention. Quite often, it is not the question of patent versus trade secret, but how to leverage the investment in the exit. And it's definitely the exit that makes then the difference, whether the investment in the patent or trade secret has paid out. And investors, has already been said, private equity and venture capitalists, they look very closely these days on the value of the patent portfolio. Right, then we have, of course, the legal frameworks. Here in Europe, we can be very proud of the Trade Secret Directive of 2016 that has worked out very well. And also the patent, the European patent, is, of course, it's got a bit of a cost issue, but then once we have the unitary patent, we have a very, very good legal framework for patent and trade secret. When to patent and when to keep the information secret. We have the patent, which is more for the concepts, the bigger picture solution, how is the problem solved, and then how exactly is it done. That would be then the realm of the trade secret. Then I have some tips on how to find a patent, which are freely available and totally inexpensive. Patent Scope by the World Intellectual Property Office. We have Espasnet. Patent Inspiration would be a commercial provider, but they offer a free entry with very brilliant graphs which show easily give access to benchmarking for SMEs. Then how to oppose a patent, that I will not show, but for those who are interested, there is a very good tutorial, 5 minutes, by the European Patent Office. And of course, if you have questions, feel free to reach out. Thank you.
Thank you very much, Dr. Wilnecker. I think this was very practical, also the costs and how also that you compare then the trade secrets and the IP. I think this is very valuable for our SMEs, and we discussed this in the debate more and deeper. And now we're coming to Dr. Paul Rübig, Honorary President of SME Europe, a member of the EIT Governing Board, member of the European Economic and Social Committee. Give us a view of the new IP strategy of the EESC, and also perhaps reflect a little bit what we heard already in the keynotes. Please, the floor is yours.
Yes, first of all, many thanks. I was very impressed also by the speech of Ivan Stefanec. I think Ivan brought it very good to the point that we are living in a global competition. And, you know, for me as a blacksmith, it was always clear that if we have new technologies which we could get secured in the global competition, it would be a big benefit. So in my young days, I got a patent for forging a hole into a linchpin. So a forged hole into a linchpin was something very original. And at this time, I was at the university in Linz. So I asked if I can write my thesis about international patent and license policy. And then I went to Switzerland to speak with our specialists there. I went to United States, to the Duke University, you know, which is the #1, which is sponsored by Coca-Cola on intellectual property. At this time, of course, we had a lot of books about lawyers' interests into this area. But I think I was the first one who published a scientific publication on license strategies. So the principle was that we can find patent policy active. You know, active patent policy means you apply a patent. Of course, you have to see that it must be an inventive step and into a durable industrial application, like Dr. Udo Buch said. And anyway, many thanks also for your presentation. I know that the EPIS is doing a wonderful job for all of us. And we know that if you apply a patent, you have 1 year time to rethink where you can get your patent. So if you look to the strategy, of course, it's clear to say, okay, maybe it's wise to get a patent in the area where you live, to be protected around you, but where it's produced, maybe where the new product is produced, or where the competition is. So where is the largest market? So the strategy where to file a patent is quite important for the cost issue, because you can have a national parliament, you can have a national patent, you can have a European, to say so, patent, and you can go to anywhere in the world to file your patent strategy. So there is also a big difference on the security of the patent. You know, in Europe, and Austria, I think, was one of the first countries in the world who started with a patent office. And, you know, if you get a patent in Europe, it's checked in detail around the world if this is really new. So if you get a patent on European side, you can be sure, or very sure, that your patent will be strong and could be defended easier. Yeah? If you go to United States, you very easily get a patent, but then you have the big risk of being defended very easily, and that the costs of getting to court could be quite high. So the strategy is always, where is your market? Where could it be produced? Where is the competition? And how big is the competition? So for small companies, of course, patent protection gives a good background. big companies told me that if they fight against an SMEs and put a lot of money in it and take a lot of lawyers, then every patent could be destroyed. But on the other area, you can also try to put patents around your patent, with more or less going into the same direction. So you also could run this active patent strategy. The passive strategy is to fight other patents which are coming near to your idea. It's also good if you have a trade secret, because also with trade secret, you should be careful if it's really secret and if it's not published. A third party could try to get a patent on your trade secret. And then, of course, you run into serious problems. So also to know the procedure, how to protect a trade secret is, I think, crucial for the future. And we all know that Europe lost a lot of space in patent applications. As Ivan said, China files 4 times more, United States 3 times more. I think 30 years ago, Europe had 50% of the patents and China 5%. And now it's exactly the other way around. That China get 50% of the patents and Europe only 5%. So the overall innovation strategy in the European research area, and I'm also rapporteur in the European Economic and Social Committee for the European research area. And therefore it's clear that we have to take care how to help SMEs to make the right decision. So from my practical point, as I filed my patent for the linchpin, I got the patent and I'm very proud on this wonderful document you get. But on the other side, the production process, how we really forged it, we made a trade secret. So nobody should know how we really have done it. So we have a kind of double protection in the process. We know exactly how to do. And on the other side, if they are coming out with the finalized product, we have the patent protection. So you see, it's a practical guidance, how important IP is. And I would say the work on intellectual property is a key issue that in future time we can earn good wages and can play this power game on the global competition. Thank you.
Thank you very much, Dr. Paul Rübig. I think it's very entrepreneurial point of view. I think it's important to see that you also have to focus on the market and where the competition is. We coming directly to the debate, but I want to give also Dr. Udo Buchs a chance to reflect what he heard. Now from our keynote speakers, please, the floor is yours. And please, for the audience, use the question and answer sections below in this task list, task down, and use this function, please.
I had a question to Eva Willniger on the costs side. Is that meaning that it is filing with the European Patent Office or with the national patent? And what do you advise when it comes to markets where I want to have the protection for my invention? How do I know if I'm better if I file it in Belgium, or is it valid for whole Europe? How does that work?
Yeah. Thanks, Dr. Buchs, for the question. So the question is, how do we determine the 200,000, which I put up for average cost fee over the lifespan of a patent in the top 5 markets, which is Europe, US, China, Korea, and Japan. That would be the average cost based on an over the lifetime, the annuity fees and the translation costs, the fees of the patent office, and the fees that one has to pay the patent attorney. So that would be now when to decide how to effectively protect. that very much depends on the industry. Yeah? So in automobile, if I have a German patent, that is worth a lot because that's the main market in Europe, and I can probably not produce a car that would not enter the German market if I'm active in Europe. So this depends really. Automotive is different than data processing, or data processing is different than pharma. So if you look at the industries that would validate in most of the countries, and I'm sure Mr. Meunier will confirm that pharma would take the most countries by far. Yeah, biotech on average would validate it in 10 European markets. Those who don't require translations, because one has to translate it to Polish and Turkish, 70 pages, it gets just, costs get easily out of control. Yeah. Does that answer your question, Dr. Books?
Yes, thank you.
And Dr. Paul Rubik?
Very interesting question, because in my studies a long time ago, but also in the meantime, it's a very good question where to file the patent the first time, because it makes a big difference if you apply with your patent the first time in Belgium, in Austria, in Switzerland, in Singapore, in China. So if you look into the return on investment and onto the revenue of the taxation, it makes a big difference where you start to file your patent. So first of all, the most important thing is that you keep it secret, because it depends on the time when you present your proposal to the patent office. If it's published also in a small circle, you can't have a patent anymore. So from the secret to the patent, it's a very important step to keep it with your patent attorney really secret, that he files it to a very professional and basic defense structure. And then you should decide who is filing the patent, if you do it as a company, if you do it as an employee, because all of this would have a big effect on what the outcome in the end will be. So also for an employee, it's important to speak with the responsible people in their own company, how to handle these revenue questions on the patent. And at least it's also very clear to see which license strategy you make. You can make an active license strategy to sell license out of the patent, but you also can make a passive license strategy, that you look around the world if there is a patent available which you can use and get return on investment, and then you can buy a license, maybe by royalties or whatever. So if you look to the balance of the global license statistics, and I think it's very important to see how we buy in patents or buy out patents or buy license or sell patent license. It's a very big revenue stream, and it's totally underestimated in the public how important these revenue streams in, let's say, export import to increase the buying power of our people, because if you sell it, of course it's getting up, like to say export, it's getting revenue, and if you buy it and you can do something cheaper or better to distribute it around the world, it's also doubling the buying power and the wage situation. So we should not underestimate it, how important IP is.
Thank you very much. Only for the audience, I'm collecting all the questions. If they are very specific, we will have them on the end. Now we're discussing first the general topics, and I pass over to Mr. Meunier. Please, the floor is yours.
Thank you. I would like, so I fully agree with Mr. Rubik's comments, and I would like to elaborate a bit on that, and especially to come back on the question of costs. I think there was the discussion on Europe losing ground to the US and China. I would connect that discussion to even a kind of cultural mindset, actually, and I think it's an issue of seeing IP and patents in that case as a cost or as an investment. And I think really that there is a mindset issue sometimes in Europe in that respect. It's not only a cost, a box that you have to tick that you have a patent. You have to ask yourself, what kind of value do I want to create and capture with this patent? And this drives, and then you can leverage it to create value. We have, I would like to mention that we have produced a number of case studies of SMEs in Europe that are easily accessible on our website, www.epo.org/SME. And one of them, for instance, is Aerogen. It's an Irish startup that has become a world leader in aerosol drug delivery. And they are an SME. But what they did is that they have a strong patent portfolio, and actually strong enough to contract with companies like Philips or General Electric to distribute their technology across the world. And in that respect, actually, the investment, it's really an investment in the patent portfolio that makes it possible to enter new markets. That being said, the cost remains an issue, and they told us they would like to see the unitary patent because they have to trade off protection in some European countries versus some non-European countries, for instance. And that may mean that they do not enter some European countries today. Another remark, so talking about value seeing patents as an investment, value-oriented, this has strong ramification for the organization. This is where also the cultural mindset issue is. It has to be proactive patenting, and it has to be aligned with the strategy and with the management practices beyond the IP. So it's very important that the top management is aware of that. It's not only the issue of the patent department, it's the issue of the company, actually. And this has ramification, as said by Mr. Rubik, in terms of IP capture. It's important to monitor constantly what are the new inventions coming out. What do we keep secret? What do we patent? What do we keep secret to the moment until we patent them? Because if you don't do that, you do not control the flow, and you may disclose inventions too early and lose the patent. Yes, and I would last say that this is especially important for SMEs because they are resource constrained, and so they have to focus their resource on the most powerful way of creating value, and so they have to pick wisely what they protect. And so it's important that this decision goes up at the top level of the company.
Thank you very much. I want to come in this discussion back to the enforcement, not only to the costs, also the time framework, because we have not only in China, so also problems in the European Union. It takes sometimes years to enforce the patent. We had the cases, and then also after the decision is made by the court, that really the best action takes. And this is well known and nothing happening. And we have many complaints by SMEs that this case is not rare. So what is it? I think you're losing market shares, and then after this, how you get your money back after years, even if this company is popping up and then closing again after they make the share. Eva Wilnecker, perhaps you can say something about this.
Yeah. That is definitely, so if I understand the question right, so there is some kind of abuse. So if one is attacking a company, the company will close down and open up company B. Is that the question?
Yes, exactly.
So the length of the proceedings, that's definitely an issue, but that can be handled by seeking appropriate advice. And there are countries, for example, in the US, the International Trade Commission, that you get a judgment within 6 to 8 months, right? It can be, it's not going to be damages, it's just going to be an injunction, but it's very effective. So there are very effective means. It's just you have to seek appropriate advice. It's a very specialized matter. Then with enforcement in other countries where we have an enforceable title against company A, and it just closes down and company B does the same thing. Now that's a rat race. I don't have the answer to that, but maybe my colleagues have.
I think we had extreme cases in Eastern Europe where it takes, with us related also perhaps with corruption, I don't know, but it takes years, and it is well known also by the authorities. from countries like Austria or Germany, that it takes really a long time to enforce also then the decision of a court.
Yeah.
This makes already losings in high rates, and then these companies went bankrupt, and then there was nobody to enforce the revenues. This is a problem. Then another question, perhaps also from the audience, to you also, Ms. Wilnecker. Could you please explain how public funding leads to inflated IP fees? I know it. I can know it because also your colleagues are clever.
Sorry, I'm not sure that everybody understood the question.
Yes, this is about because the Wallonie is funding 50% of the costs for the EP fees, and I think some of the colleagues of Ms. Wille are clever in raising the prices because of this. So to get more of this.
Yeah, so we are actually, I mean, that's my personal opinion. So this is the impression I have, and it's probably not it's just we are in a digital age. If you have a fully digital office, then you can actually go down with your pricing quite substantially. What I see is that the 20th century prices are quite maintained, and that's you know, if there would be not that incentive of the subsidies, maybe they would have to be more competitive, and that would
the market. And then you explained it well. We have also another question. What is with Africa? What are with such regions who are perhaps how to enforce their patents, how to do this there? Africa, I think it's very special, perhaps.
Yeah, so let's take, for example, Namibia. I have a cooperation with the Namibian patent office, and guess how many inventions they have had last year? It's more.
But then it's I think more about the enforcement than in Africa. Is this a problem?
Yeah, obviously, if you go to a Nigerian court, it will take a long time, and they have maybe 20 patents per year had in the past. I mean, that will be evolving, but the courts are not that experienced, and they are not yet I mean, if you have a patent infringement, you need a country where you have effective enforcement measures. So China is catching up. We have the US and we have Germany, right? So this is where I would recommend to go for effective enforcement. Africa will catch up, that's for sure.
Okay. Then we have a question, also a general questions. I choose Tommaso from EPO. To what extent does reverse engineering influence the choice between patents and trade secrets? Is it correct to say that the more likely RE will be, the more likely people will option for patent, while the less likely RE will be the more likely people will choose trade secrets?
Yes, this is correct.
Yes, it's correct.
This is one of the main drivers of the decision to whether to patent, and one of the challenges also is to monitor reverse engineering, or to know also whether the invention can be hidden to reverse engineering. And there is the famous example of the tires. So Michelin has been for a long time a believer in trade secret, because it's difficult to reverse engineer a tire. And now they file patents, actually. So they have been reverse engineered, and they changed their strategy. And this to say that there's a lot of innovation as well in reverse engineering.
Okay, thank you very much.
Shall I raise the hand?
Dr. Books, yes, please.
Sorry, I can't find the raise hand function. No, just on the enormous amounts of patents applications, we sometimes, as Europeans, we get scared when we see how many patents are filed in China, coming from China. Just want to relativize this. I am sure that the EPO can somehow confirm. It's often they have patents. Of course, they get a patent in China, and the internal is very cheap, it's very fast, and it's sometimes things which are only for the Chinese market, which are not at all interesting. I'm saying it's a lot of crap also, which they patent. So we should not be scared of this. And then sorry to ask for the machine translations which were mentioned. I would like to know if this is Google Translate or is there special tools, and is this then accepted by the European Patent Office, for example, machine translations?
Then Mr. Minier, please.
So there are a lot of elements. So on patents in China and the US, yes, indeed, it's so the patent system is not the same. The thresholds for patenting are not the same, and so we cannot directly compare the numbers. And what is comparable is the number of patents that are extended internationally, and that concerns only a small fraction of the patents in China, for instance, but still not a negligible one. And this is sometimes very impressive technology in 5G or in artificial intelligence, for instance. So it's not negligible, but the orders of magnitude are much smaller. And to me, that raises the question of the harmonization and quality of the international patent system. And there we have to anticipate, we have to look forward. And this concerns Africa, that was discussed. So indeed, there are few patents today in Africa. Some time ago, there were a few patents in India or in Vietnam, or even before in China. So it will come. And it's important to help them prepare for that and set up the right system. And so this is an important strategic priority for the EPO. And we already have some validation agreements with Morocco, for instance, so Tunisia in Africa, where they recognize actually the European patents. So European patents can be validated directly in these countries. And we are in advanced discussions with other African countries like ARIPO, so a group of African countries to extend the validation agreement. And as a counterpart to the validation agreement, we train them. So we provide technical assistance, tools, training that can be helpful to have a quality patent system, including on the litigation aspect. So I just wanted to mention that. Concerning the translation, so what we have is tools for translating prior art, and that is very important, because now we just discussed that there are a lot of patent applications in China, in Korea, and they are valid prior art, and so we need to examine inventions against this prior art, and we use machine translation for that, and now it works. The system is very mature and works very well. And we have the biggest databases in the world in terms of prior art documentation, so patents, but also non-patent literature like standard specification, for instance. And this is typically the type of resource that we can share with our partners in Africa or in the rest of the world.
Thank you. Another question, can it be, how often is happening that it's a mixed approach? So in robotic, the robot has a patent and the software is a trade secret. How often is this? So that companies use both to protect the products.
Of course, all the time.
Always.
I would say no.
So this is the most common approach, or is this likely if it's only that you mix?
I tried to show this was maybe the basket, the sneakers. You have the design, you have the label, you have the trademark, you have the patent, you might have a trade secret all in one product.
Okay, thank you. And the second thing, is there data that SMEs are searching for strong partners because they are afraid to alone to protect the patent, that they are only finding a large company to enforce this? How often is this that they say, okay, it's for me too difficult, it is really a global thing, I need a big partner, not only for selling it, also to protect it? How often is this happening?
So if I may, on this one, I actually, we tested that. So we studied that, we surveyed SMEs, and that was my expectation, but it's not what we found actually. So in half of the cases, they work with large companies, but in half of the other half, they work with small businesses, and they do not particularly prioritize large ones. So it's really open in that respect. So certainly large companies are valuable partners in certain cases, but not in all. And typically to enter a foreign market, for instance, in Europe, a partnership with another SME can make a lot of sense, or by pooling resources and expertise to address a new challenge.
Thank you very much. And then we're coming to more specific questions from Enrique Fontes. He represented the European Major Exhibition Centers Associations regarding the priority of exhibitions at fairs and the definition of international fairs contained in the EU design regulations. Do you think that reform of the regulation should be used to include a definition of international fair that is not limited to universal exhibitions and which will also cover the standards that the industry used to define what an international fair is? Perhaps Dr. Wilnecker, please.
So that's a very important point. And so the question was commercial prior use at a trade show. Should that be not novelty destroying to a design or to a patent application? Same thing here. And I fully support that, because we have other countries like Japan or the US, which have a grace period. The US of 1 year. In Germany, we have that with the utility model. We have 6 months grace period. That means I can try out test the waters with my invention and then still work on it and then file it. And it's and if I have to file it and then I can only exchange or have to foresee confidentiality agreement, it's less subtle. So I would fully support that, but I don't know how these discussions stand at this time.
Then another question: is there a possibility to have an assurance on a patent to protect me as an SME? Who could answer this? Dr. Rübig, please.
Yes, in principle, of course, you can find an insurance who takes law cases, but normally it's quite expensive. And the question is, if the case comes up, if they really will fight for you. So, of course, it depends on the insurance company and maybe the broker you take, but from principle, it's possible.
Thank you. We got another question. I think this is interesting also for startups and very SMEs from the top, from the health sector. To Mr. Books, it is a good idea to stop patent protection for vaccines in Africa and compare it.
This is a very political question. Of course, I support the European Union approach, which is always to say, in the case of medicines, it is not only the patent, which is the story. You lift the patent, but you might not be able to produce the vaccine. It doesn't help you. It's very easy to say, lift all the patents, for our European or German vaccines. But then you have to also have the know-how to produce it. So that's what we tell the United States or countries like South Africa or India, which are very much pushing on that point. But we could also say, please, dear Google, dear Huawei, it's very important that we have a computer which we advance in. Technically, the world need you. You have to lift the patent on Google or Amazon. So we don't do that, but they ask us because by coincidence we have the vaccine. That's my personal opinion.
Thank you very much. Dr. Paul Rübig, please.
Yes, first of all, a patent is always open and transparent for the world. So for scientific use, you can use the patent at all the time. You know all the details which are filed in the patent, and it's a very good base for further research and education of the people. But if you want to use it commercially, of course you have to pay for it, and that's why we have license agreements. And whoever pays the license is something different. It could be paid by the country in Africa who want to have it. Could be paid by a private company. could be paid by European Union or by a US government. So I think it's very clear that the TRIPS agreement also could enforce the use of patents, but under certain conditions. And it makes no sense to destroy the value of a patent in giving it free for production, because the production, as we have heard today, it's also necessary to know the trade or the production secret, so to say it clearly, because also in the production, there's a lot of secrets. You know, a lot of people say, yes, vaccinations is done easily, but you know, it's a difference if you produce 5 pieces of vaccinations, or 1,000 or 1 million or 1 billion. You know, 1 billion, nobody really can estimate how big the investment is, and how difficult it is to get all the certifications for producing such a patent. It's very complex, and only these very big companies are able to do it in a proper and certain time. And I think the European Union made a perfect decision to file it together, to take care on all these difficult questions, also from the IP side. And I think it's much better to buy the products from the companies which are doing it, or ask them to put a licensed production somewhere and to pay for it. And you have seen that the Russians are going to Africa and offering full plants to put it on Earth. And then, of course, with the advice of the people who know how to produce, the certainty is there, and the security for the consumers and for the patients. So only lifting a patent makes no sense at all. It's a very primitive political question to say if you lift the patent, everything is solved. It's the opposite. Yeah, it will start with a lot of problems, and so therefore I think lifting of patent makes no sense at all.
Thank you very much. I think this is an important point, because if you develop a patent, you're collecting also data, you know how to produce it. And I think only to have the patent alone means not that you can deliver this in the highest quality. I think how many, before we come into the last questions, how much is the consumers aware about patents and quality? Normally, you are checking the name, the brand, made in Germany. Are you checking? There's often also an IP patent number there. But how often really, if B2B is clear, but how often really consumers making a decisions because I have the original patent producer? Is there some data from consumer sides that it's an advantage in selling?
You know, at least it's a unique selling proposition. If you get a product where there's a patent on it, you know that maybe you can't have this product somewhere else. So it's also a guarantee that it's new, you know, at least not older than 20 years. And so therefore, I think a lot of people are writing only the patent application on their products. A filed patent is something else. So if you have really a patent number which gives you all this protection, and I think these patents are weapons, is especially for SMEs a very good sentence. I really like it and enjoy it. If I think that's exactly brought to the point.
Mr. Menier, perhaps also two questions to you. Should we more promote awareness to consumers and also work together with consumer protections about patents? I think it's not so in the public discussion or so on, that this is also a quality point of a product, please.
Yes, so indeed we perceive a need to raise awareness on the role of IP, and the role of IP in the society in general, and even very specifically in universities, among future engineers, future scientists, future researchers. They need to be aware of IP and to take that into account in their future professional role. So that's the best moment, and this is where we invest most, besides through our European Patent Academy, besides our general efforts to like the European Inventor Award or studies showing the benefits of patents to the economy. If I may just add one point concerning the consumers and the perception of patents, I think it's important also to have in mind the risk of counterfeiting. And actually, IP is very important there because it's an incentive for the owner to fight counterfeiting, and that is often overlooked. But in fact, if you don't have that incentive, then you need a check mechanism to avoid counterfeiting, and we see that there's a lot of counterfeiting in this market.
Thank you much. I think this is a very important point and clever that the private sector is protecting the consumers for counterfeiting. Now we come into the last questions, the last round, and it's about digitalization. I think it's very interesting. It is from, I cannot read the name now here, Peter Regner, to develop the digital exchange of intellectual properties and make an EU regulation for this market for all countries in EAA could be a very important step to bring investment for the innovation under EU regulations. Do you think could be this developed in Europe Union? Do you think could be this developed in Europe Union? So is this question clear? Ms. Willinger, Dr. Willinger, you are seeing you would like to answer this question.
Yeah, absolutely. I mean, I do think in the monetization of IP assets, we still have a long, of course, keeping the competition at a distance, the exit, increasing the value proposition of the company. There are many, the quality, we've heard that, but then there are many patents which are unused, right, and or are not enforced, and then this something like that could help with the monetization of those assets, and then draw further as a encourage further investment in innovation. I do think this is very exciting. I'd absolutely like to learn more about the tax aspects of that, and I'm sure my colleagues have other comments on this future.
Thank you very much. If there is no comment, we're coming to our end. And I would like to have a last statement of everybody, perhaps a resume about this webinar, or a wish, or something else. Dr. Udo Buchs, as initiator of this, you are happy with the discussion. Please, the floor is yours.
Yes, I was very impressed about the quality of the speakers. Apart from my own, which was not so good, but for example, what I learned a lot now and I was very happy to learn from Mr. Meunier that the European unitary patent is basically one step before coming into force. We heard from him that Germany finally has ratified the United Patent Court Agreement, which is an international agreement. We have lost on the long way since the 90s. We have lost a member who was getting tired of us, the United Kingdom. So I hope this does not hinder and jeopardize the coming into force of the European unitary patent. And now we have the last obstacles overwhelmed. And so that is, of course, that would be a real mind change for European businesses if we could have a real EU patent. Because as you know, the European patent we have now is 38 member states. It has nothing to do with the European Union. Of course, all member states are member of the European Patent Convention, but a European patent with the 12 stars on it and under the jurisdiction of the European Court of Justice, that would really be a trademark for the whole world. And so today seems to be a very good day. Thank you very much.
Then I will pass over to Mr. Meunier, please. the last words today in this webinar for you.
Thank you, and I would like also to thank you again for the invitation and to stress how important this topic and this event is in our view, and how timely also. I think we know that we are seeing today really a fast acceleration of startups creation and development in Europe. And this resonates with the EU Green Deal and the digital transition at the EU level that really push in that direction, push towards deep tech startups. We have ecosystems being deployed with more savvy investors. And it's really a perfect time to realize the single market for technology. And so it's a very good news and very good timing indeed in our view that the unitary patent is coming to life at last. Thank you.
Thank you. Dr. Wilnecker, your words now.
Yeah, thanks again for the invitation, Dr. Books. And then it's been a pleasure to talk to have this discussion. And I really encourage all SMEs to engage in an IP dialogue, because there's a lot of experience that other IP peers, also SME peers, might have gained, and that can be shared. Thank you.
Then, thank you very much. And the last words from Mr. SME, the political perspective, Dr. Paul Rübig, please. The floor is yours.
Yeah, yes, thank you so much. You know, in the European Economic and Social Committee, I am the rapporteur on the European research area. You know, European research area, we should have 3% of the GDP. That's approximately 450 billion euro every year, which is invested in research and science. We want to have in the new strategy going up to 4%, because we learned that this area brings the best growth of GDP. If you look to South Korea, you have seen that they are going above 4% and they have the highest GDP growth. So I'm also on the board of the European Institute of Technology, where I pray every day, please use IP as a standard tool to accelerate our economy into the right direction. You know, in EIT, I also pray that work together with all European agencies. We have excellent agencies, more than 40, but most of the people don't know them, and work together on the global level, like on WTO level, where TRIPS is from utmost importance. What I learned is that the Chinese now understood how important IP is. That was not 30 years ago. And I have the feeling we still lose a little bit the importance of IP. It's a lot of people fight against IP because they don't understand what it's all about. And maybe this debate is also enlightened from people from outside of European Union to weaken our development. But therefore, I think we need a new strategy for IP. Horst, I've sent you a link to the European Economic and Social Committee, where we have written also a report on the new IP strategies for the European Union. There's a basic document from the European Commission. And I think we should do our utmost to bring it to our SMEs, how important trade secrets and patents and IP for the overall development is. So thank you very much. I'm very proud, and I also learned a lot in this debate. And let's go on. I know that Udo got my book about license marketing and license policy. You know, it's now, I think, more than 30 years old, but the principles will last forever. Thank you. Bye.
Thank you very much to all the speakers, to the host. I have to say it was very interesting. I think we cannot do often enough such events. And I would also ask the European Patent Office to send us perhaps the links for the academy, how they promote patents. We can share this with our SME community. Thank you also to Eva Wilnecker for this practical point of view. I think if questions are coming up still from our audience, we will share it with you. Thank you to the books again. I think this is very interesting that also that you coming up to us actively, to our SME community to promote this topic. And Dr. Paul Rübig, of course, as our Honorable President, thank you that you are always active and supporting these topics. Thank you, have a nice day, and we will see you soon again, I hope.